Hello and welcome to Self-Represented in Family Court. Your host, Tracy Bee. That's me. So, dear, we discuss strategies. Yes, strategies and how to use them to get the results you want in family court. If you're self-represented, pro se, pro per, or if you have an attorney and you just need to know what it takes to get through this complex family court system we have, this is the place to be. We discuss strategy. We discuss tactics. We discuss tips and tricks. We discuss techniques. We discuss secrets. We discuss it all. Whatever it takes to get you the strategy that you need, that's it. That's here. That's what we do. So sit back, take notes, and kick ass. Well, hello there. It's me, Tracy Bee, and you're listening to another episode of Self-Represented in Family Court. Thank you for being here. I really appreciate you listening. And please tell everybody about the show. I'd appreciate that. So, this episode will be aired the month of October, which is Domestic Violence Awareness Month. Yes. And domestic violence and family court have a love-hate relationship. Why do I say that, you ask? Well, for some reason, the legal community, the family court part of the legal community, don't really take domestic violence allegations very seriously. Let me just back up a minute. It's not across the board. I will say this. The court process itself does not take domestic violence seriously. And I want to spend this time today, this episode, to talk about restraining orders, particularly, because restraining orders often get denied. And although most restraining orders are not issued directly by the family court, because it depends on the circumstances by which you're requesting one. I know in New York, for example, you can get a restraining order just by calling the cops or going to the precinct. And then you can get one in family court. You can ask for a restraining order in family court. There are criminal restraining orders, and then there's civil ones. Most of the ones in court are actually civil. If you get the police involved, law enforcement involved, it's usually criminal. And sometimes they overlap. Sometimes you can get both, actually. Which one you get? Well, that depends, because the criteria for each usually differs. The standard of proof for anything criminal is going to be a little higher than anything that's civil. So the criteria for getting a civil order of protection, restraining order, domestic violence order, whatever it's called in your jurisdiction, is usually going to be less strict, less stringent, because it's civil. What does that mean? That means the civil penalties, consequences, may not be as severe. Now, it gets a little tricky, because sometimes in some places, if you have a civil restraining order or order of protection and the perpetrator violates it, that can be criminal. That can be a crime. The violation of it can be considered a crime. Not always. Not always. Check your statutes. Check your laws. Check your rules in your jurisdiction, because it can really get tricky, and you really need to know what the criteria is and what the difference is with respect to consequences. You know why? Because there's a lot of restraining orders that are being denied, both civilly and criminally, and there are people really getting, unfortunately, subjected to some real danger, some real harm, because the court, the law enforcement, erroneously denied the order of protection or the restraining order, leaving the, I hate to use the word victim, but the victim, the attacked, the assaulted, the one that is the target of the violence, of the domestic violence, vulnerable to having no protection. Now, let's be clear. Having a restraining order or having an order of protection is not automatic protection against any harm from the attacker, from your accused. It doesn't, Because it's a piece of paper. And as I always tell people, it's a piece of paper that does not have legs, arms, hands, and feet that's going to walk into your home or your surroundings, your environment to protect you. It's a piece of paper. If your attacker wants to ignore that piece of paper, no one's going to stop them because they're not preemptive. You can only pursue the actual violation of it. You can't pursue potential violation of it. So in other words, someone will say to me, "Hey, Tracy, I have a restraining order, but this person keeps harassing me by sending me emails or sending somebody else to drive by my home, and who do I call?" And unless that's a violation, and sometimes it is a violation, but unless it's a violation and you have proof, then no one. Because if you call the cops and there's no one there at your home and you have no proof, it's just your word. Cops have a lot of discretion. They have a lot of discretion. They can say, "Ma'am or sir, there's nothing I can do. You have no proof." So what do you do? Or how about in the instance where the other party, the attacker, the accused, hasn't been served with the order yet and they quote unquote violate it? Again, nothing and no one stopping. And no one's going to preemptively stop them. No one's going to stop them physically from a practical standpoint. And unfortunately, that's where the danger is. Because it's a piece of paper, some of these attackers, some of the accused are so adamant, so determined that it leaves you vulnerable because until something actually happens, and sometimes that's something, you can't come back from that. They're not doing anything. They have not, quote unquote, broken or violated the law or the restraining order. And that's where the danger comes in. Okay, but let's back up to those denials. You're denied a restraining order or an order of protection or a DVO. You're denied by the court. You're denied by the judge. You're denied by law enforcement. They won't actually give you one. What do you do? Well, again, in some instances, if you're denied for a criminal order of protection or restraining order or DVO, you might be able to go to get a civil one. You may be able to, if one doesn't work, you may be able to get the other. But suppose you don't have that option and you believe you're in serious threat of harm from this other person. And it doesn't even have to be someone you've had a direct romantic relationship or intimate relationship with. It could be anyone. But for our purposes, we're talking about someone that you are in a relationship or someone you're in a relationship, their new paramour or significant other. Because that's a common situation. That's a common dynamic as well. So what do you do? Especially when you have children involved and they have to see their children. But every time you have to interact with them, you're, being intimidated, harassed, threatened. What do you do? Well, I suggest you don't go and try to get a restraining order until you're actually ready. You have to be strategic about even requesting this order. You have to. Because if you are in a place where you don't have options about pursuing criminal or civil, if one doesn't work and then, you don't have the option to go and get the other, then you need to be sure you need to do everything you can from the start to ensure that the one that you are pursuing, filing for, requesting, has a stronger chance of being granted. What does that mean? Well, what I always tell you, what I always tell everybody, the one thing you need to know, because even if you get a criminal one, judge still has to enforce it, has to sign it. So it may not be the family court judge, it may be the criminal court judge. If you get a civil one, then the civil one is going to be signed by a judge as well. In most jurisdictions, there's usually someone of authority that will sign it. Well, you need to know who that person is. You need to understand their perspective, their view on orders like that. What does that mean? Well, you need to know if you're going to go on a Tuesday, and you should know, you should definitely know which judge is going to actually be the one to decide. You need to know what this judge's position propensity is to do in situations like yours. Yeah, Tracy, that's a lot of preparation. Well, you know what? You may not get another chance. You may really need to ensure that you get this order right now. And so you can't take any chances of it being denied. Which one would you rather? Putting in more work and effort to ensure that it does get granted, or just saying, I give up because it's too much work, and to subject yourself to the possibility of being harmed or your kids being hurt? I don't know, but if I were you, if I was a betting woman, I'd bet you'd rather go ahead and take the time to prepare. So yes, find out who this judge is. Who is this person that's going to hear my case? And a lot of times you get a temporary order and then you have to come back for an actual hearing to make it permanent once it's granted. But I'm talking about the initial application, going in to get it in the first place. Because sometimes you could get a temporary order, right? You can go in today, get a temporary order, and then come back in another week or 10 days and have it finalized, or the judge will decide how long it's going to be. That judge, you absolutely need to know who that judge is for sure. But I'm talking about even to get the temporary order, because you can get a temporary order and make it final. You can't get a denial and then go back and get a final. It doesn't work like that. So you need to get that temporary order in place. So for that temporary order, that initial order, you need to find out who this person is that's going to hear this initial application for this request. Some judges are really, really lenient on DV and some aren't. I've done criminal law. I know the difference in these judges in their position on domestic violence or intimate partner violence. I've done criminal trials in front of judges, and I know some of them, their stance is very, very lenient, very lax. And then some of them don't take any crap when it comes to any sort of violence against an intimate partner or a paramour or a spouse or children. And I know I'm at an advantage to know that, but it's not hard. It's really not hard. You can go in and observe judges, because it's usually the same judge or the same rotation of judges. You can go in and pay attention, watch them in action. Some courts usually have a specific time where they're heard, or a specific day, or something like that. Most courts have it every day because a lot of times they're emergencies. If the person is being arrested, then you probably don't need to. I'm talking about when you're going in to request an order. If the person has been arrested, or if the police told you that they're going to be arrested, there's a warrant out for their arrest, you may not have to do much. Because in most jurisdictions, the prosecutor, the county attorney, or whatever they're called, that's the one for the state that pursues crimes against defendants, they're probably going to ask the judge for a restraining order on your behalf. And you do have some input with that too. You can speak to the prosecutor and give them insight as to how long you want it to be, who you want it to include, which places you want to include to make sure that they stay away from. You should definitely communicate with the prosecutor in that instance. But back to when there is no crime, there are no arrests. The crime is the restraining order. That is what you want to be considered the crime. That is what you're pursuing. How do you ensure that the judge that's going to hear this or sign this is going to be the one that you need to sign? They are going to be one of those judges that I mentioned that doesn't take any crap when it comes to violence against you and or children. Get a heads up. Speak to the personnel in the court. Speak to other people in your area. Speak to law enforcement. A lot of them know. A DV advocate or DV organization is always helpful. It's always helpful to talk to someone in a DV organization. Even if they can't do much for you, you can always call and ask them questions. And that's one of them that you certainly want to know. See, I'm one of those people that I reverse engineer everything. So if I worked in a DV organization, even though there was limited, help or assistance I can provide with respect to getting a restraining order, you better know that I know every single judge, you have a greater chance of getting one granted in your favor. And I'd be telling you that. So that's one way you could do that. The other thing is, what do you need to prove? What are the elements? What are the criteria? Because it's going to change. It's going to change from place to place, jurisdiction to jurisdiction. What are the elements? You have to prove that there was an incident, and you have to prove that you're in fear of safety for any future incidents. Right? That's usually the general principles. Well, how do you prove that? How do you prove that? To increase your chances of getting the judge to believe you and to grant it. Because the judge can believe that there is or there has been some incidents of violence. They can and still deny you. Yeah, I bet you didn't know that. Absolutely, they can. A denial doesn't mean they didn't believe you. That means that you didn't meet the criteria. You didn't meet the legal requirements. Or it could be the other way around. You met the legal requirements, but the judge didn't find you credible, didn't find you believable. Yep, those are some of the reasons why. I mean, in addition to things that we are not aware of, influences, persuasion, bias, conflicts, a myriad of things. It can be any one of those things. So how do you actually get up there, tell your story? You're emotional, you're afraid, you're tired, you're intimidated, you're overwhelmed. How do you get up there and concentrate or focus on what it is you need to relay to the court to ensure that you get this order granted? Well, you make a case. Sure, you tell a story, but you tell a story, you make a case with telling that story. Start with what happened. What did you do? You want to make sure you relay something or convey what you did that was not insightful, like attack them or threaten them or no. Don't go and telling a story about that you did that and then they, not to say that they, should have, especially when physical violence is involved. But no, that's not going to work because you know what's going to happen? They're going to get a cross restraining order against you. And in some places, in most places, they will allow them to do that. If you testify to something, if you don't get it dismissed and you get it granted, trust me, the accused is going to get one granted against you as well. That's called a cross order, cross restraining order, cross petition for domestic violence, cross order protection. If there's been patterns, you want to, convey there's a patterns. Whether it started out, something light, something not as serious, not as dangerous, and it escalated. It depends on where you are, what the actual harm or danger is. And then how it affected your safety, how you felt in fear of your safety, of your freedom, of your life, of your body, or something. Fear has to be an element, a component that you testify to. And then make sure you have evidence. A lot of people will go and just ask for a restraining order. And let me just say this. I'm going to take a break for 1 second and say this. I am not a fan of people encouraging other people to go to court to get a restraining order just as a means to get the other party out of the house. That gets under my skin. And for the past several months, I've been seeing a lot of that. And I hate to say this, I hate to sound like I'm stereotyping, but women do that all the time. I see women telling other women, oh, go and get a restraining order. That'll get him out the house. Well, nobody said anything about harm or danger. Yeah, well, he yelled at her, so she could get a restraining order because of that. No. Hey, he yelled at you. Did you feel like you were being threatened though? Were you afraid when he yelled? No, I'm not afraid. He always yells at me and I yell back. So where's the criteria? Where are the elements for a restraining order? And women do that all the time. And then, you know what happens? I don't see men doing that. So I know I can hear you yelling at me, but I don't see men doing that. I don't see men suggesting to other men or even women to go to court to get a restraining order just as a means to get exclusive occupancy of the home. I don't see that. I see women doing that all the time. And then you know what happens? Other women who are really being hurt or subjected to physical or mental or emotional abuse and harm, they go and they're denied. You know why? Because so many of the other women who came before them had no case, desensitized the judge and everybody else to the seriousness of the harm or the danger. And so now they think everybody is coming in making these, false claims. That is my trigger. That is my trigger. There are people, and I know some people, there are people in my family that were victims, that are survivors of abuse, physical abuse, domestic violence abuse. And so it gets under my skin when I hear, yes, women tell other women to go to court to get a restraining order just as a means to get exclusive occupancy of the home. When there's no threat of harm, there's nothing. There's no danger. There's nothing. But hey, why not? Just circumvent the legal process and do it this way. That gets under my skin. So anyway, back to what I was saying. Make your case. What's your evidence? Well, let me tell you the order by which is the strongest, the most supportive. Of course, if you have a witness, not your mom, not your sister. I mean, if that's who they are, they need to be credible. They should not come across as, lacking credibility of, just embellishing what they saw or completely making it up. They should come across as poised, as credible, as, reliable. They should not be someone you paid to come in and do this, or you owe a favor to come in and testify on your behalf. That's even worse. Some judges see right through that. You should have pictures, time-stamped, date stamped. You should have recordings. You should have screenshots. You should have audio, video, medical records, police reports. Police reports are probably more substantive than all the other things. Witnesses, if they're credible. Police reports, of course. Pictures. Everything else after that. I say police report after witnesses because sometimes the police reports, if you have a police report of an incident and there's been no arrests or there's been no orders issued, it kind of looks suspect. It kind of looks questionable. If you have a police report and you have something to corroborate what's in that police report, maybe, yes, that's better. Because if I'm opposing counsel, I'm actually objecting to the admission or I'm impeaching the credibility of that police report. If there's a police report and there's been no arrest and there's no warrants for arrest, I'm questioning the validity of that police report. So if you have police reports or anything else, like witnesses and pictures and audio or videos or screenshots, if you have medical records and you actually, in the medical records, it doesn't just state or indicate what the injury is. It actually states the source of the injury. You actually disclose that to the medical provider and it's in the report. Yes, very good. When there's kids involved, if the violence is in the presence of kids and you have proof of that, CPS got involved or CPS was informed and notified, yes. If CPS did nothing, then again, you're going to subject yourself to the attack by the other party, the opposing counsel. If there's an investigation, okay, again, most of the time when CPS is involved, they will come to court and get a guardian ad litem involved to get an order of protection on behalf of the children. Or they have their own attorney to do that. It depends on the structure of your court system. So the evidence should be admissible evidence, not just random evidence. You got audio and it's not authenticated. You got video, it's not authenticated. Not authenticated means it could be anything. You could have gotten that audio or video from it could have been, 4 or 5 years ago. It could have been tampered with. It could have been, what do they call it? Photoshop. Oh my goodness, Photoshop. Now with AI, you can make anything with AI. It could be AI produced evidence. No, please don't play yourself. Don't do it. Make your testimony a strong case. Make sure you use words, use testimony, use an argument that doesn't sound like you've watched a few episodes of SVU and you just mimicked it. If you're going to testify, if you're going to be a witness, yeah, of course you're afraid. Of course you're afraid. But there's a difference between speaking from emotion and speaking with emotion. Most judges, even domestic violence judges who typically hear those cases, they are more inclined to find you credible and actually listen to your argument if you speak from emotion as opposed to speaking with emotion. Speaking with emotion means, and you sound really, excessive and animated. And I know as a human that that's what it is. A lot of times you're being, truthful. But these judges have compassion fatigue. They're burnt out a lot of times. They're numb to that. So they're more inclined to listen to what you're saying than how you're saying it. They're more inclined to believe, to what they listen to you saying as opposed to how you're saying it. That's the difference. Speaking from emotion, meaning you're explaining, you're describing the emotion. And of course, you have some emotion in there as you're, explaining it, as you're expressing yourself. But you're not overly emotional when you're doing it. And I know sometimes it's easier said than done. I'm not oblivious to that. Even the way you present yourself. How do you show up in court? How does your tone, your body language, your image, your behaviors? Yeah, that influences judges. These judges, they hear this stuff all day, every day. I know what you're thinking. Well, then, Tracy, then they should know. Well, no. As I said, a lot of them get compassion fatigue. They become apathetic. No longer empathetic. They're apathetic. They become a little numb, a little cold to the reality that you're facing. You don't want to take that risk. You can't afford to take that risk. So, you need to, number one, consider what the criteria is in your jurisdiction. Google it. ChatGPT it. You need to know what the process is in your jurisdiction. Do you go directly to the precinct? Can you go directly to the courthouse? Can you report it to someone else and let them report it and get CPS involved maybe, or the police involved, and then let them come to you? Because that happens. How do you do it? Do you wait a day? Do you do it in the heat of the moment? Again, that's what the process is. You need to find it out. Who's the judge? What is their position? Just because they're in DV, a lot of them rotate in and out. So they may be there for a month. They might have never done a DV case. Find out who that person is. And then understand exactly what you need to prove, what the elements are, what the criteria are for the elements of the crime, whether it be assault, battery, harassment. I think that's pretty much it. Yeah, I think those are the main ones that fall under that. And maybe reckless endangerment of a child. I don't think so. I think in most places that's actually a crime. Attempted assault sometimes is a crime, but sometimes it's just enough to put in a restraining order too. Again, police have a lot of discretion. A lot of discretion. And then the DA has a lot of discretion with which crime they actually charge with. So it doesn't hurt for you to find that out too. Google it. Google is your friend. Don't ask other lay people. Ask Google, ask ChatGPT, go to the courthouse, go to a DV organization, speak to an advocate. Don't guess, because the guessing is what gets you denied, and you don't have that luxury. You can't take that chance. So anyway, I hope I help save someone today. If you're in the New Jersey area, North New Jersey, I am doing my first in-person vending event at a domestic violence awareness walk on October 25th in Jersey City, Lincoln Park. I'll be there at 8 a.m. I'm super stoked because I have some really, really cool things I'm giving away. And I will be there giving people 15-minute strategy sessions right there on the spot. Yep. So if you're in North New Jersey, come by. Look for me. I'll have a table and we'll see all the divorce solutionist stuff. So, and I will be doing them for the duration now. I will attempt to move around too as I build up my team. But yeah, my first one. So I hope I helped you. If you need more discussion about strategically getting restraining order granted, please feel free to reach out to me. We can do a strategy session. We can actually talk about some other strategies for using the denial in your case. Yep, you can use a denial of a restraining order in your actual case, your custody case, your divorce case. Yes, you can. So if that's the case, hopefully you won't be denied. But if that's the case and you want to do that, hey, set up a strategy session with me. I have, I think, 10 different strategy sessions you can choose from, depending on what your objective is. And I approach them each differently. So if you want to talk about your restraining order or DV, the issue of DV in your case and how it can impact the rest of your case or other personal things you have in your life, set up a strategy session. Go to my website, divorcesolutionist.com, and you'll see the store on the top, and it will take you right there to all my strategy sessions. So anyway, that's all I have for you today. Thank you so much for listening. I appreciate each and every one of you. Please be safe and help each other stay safe as well. Until next time, bye. We want to thank you for joining us here at Self-Representing in Family Court, where we discuss all things strategy in family court. Join us next time. Until then, visit us at www.thedivorcesolutionist.com. Take care.